Hello everybody. This is Uma from Success Law Classes. Today we are going to discuss Pocso Act case law, that is rape and murder of 3-month-old baby. In this case, the Honorable Supreme Court set aside death sentence and orders Denovo trial and held that trial court conducted the trial in a hurried manner. So the cause title of this case law is Naveen alias Ajay versus State of Madhya Pradesh. The citation is 2023 in SC 936. The date of decision is 19th October 2023. In this case, the Honorable Supreme Court held that the trial court treated the accused as if he is carrying a magic wand which is available to produce highly qualified experts. There was no opportunity to the appellant to cross-examine the experts. So, factual background of this case law is the complainant and his wife were engaged in the business of selling balloons in Indore, Madhya Pradesh, and the complainant along with his family members was sleeping at a platform at about 5 a.m. When complainant and his family members wake up, they did not find the deceased complainant's daughter at the place where she was sleeping. Despite search, they could not find her, and thereafter a missing report of his daughter was lodged at the police station. On coming to know about the discovery of a dead body, the complainant went to and identified the deceased as his daughter. Based on the evidence brought on record during the course of trial, wherein the prosecution examined 29 witnesses and also proved 78 documents including expert opinion, chemical report, FSL report, the trial court convicted the appellant for the subject offences against which the appellant preferred appeal before the High Court. The Sessions Court also sent reference to the High Court under Section 396 of CRPC for confirmation of death sentence. The Honorable and resultantly, the criminal appeal preferred by the appellant was also dismissed. A batch of 2 appeals was filed against the judgment of conviction and sentence passed by the Madhya Pradesh High Court Indore bench, whereby it upheld the conviction of the appellant accused under section 363, 366A, 376A, 376 clause 2, subclause I, subclause J, subclause K, subclause M, 302 and 201 of Indian Penal Code and section 5 clause M and I read with section 6 of Protection of Children from Sexual Offences Act 2012, the Honorable High Court confirmed the death sentence and on the appellant by the Sessions Judge. Bench comprising Justice B.R. Gawai, Justice P.S. Narasimha and Justice Prashant Kumar Mishra held the trial court treated the accused as if he is carrying a magic wand which is available to produce highly qualified experts who are government servants on a phone call. There was no opportunity in the real sense to the appellant to cross-examine the experts. We are of the considered view that the trial court conducted the trial in a hurried manner without giving proper opportunity to the accused to defend himself. Therefore, the judgment of conviction and sentence passed by the trial court and affirmed by the Honorable High Court is hereby set aside and the matter is remitted back to the trial court for Denovo trial by affording proper opportunity to the appellant to defend himself. Supreme Court, in view of the facts and circumstances of the case, observed In the case at hand, the prosecution is based on circumstantial evidence, in which the prosecution has to prove each link in the chain of circumstantial evidence, and the important chains in the link are DNA report, FSL report, and Bizarre report. When the reports were challenged by the accused before the Honorable High Court, it was brushed aside by observing that even if the authors of the reports were not called for evidence in terms of Section 293 of CRPC, the reports are not, as the defense had an opportunity to cross examine the authors of the reports during the trial. The court said that the High Court was not correct in saying that the defense had an opportunity to cross examine the experts. It further noted that the trial court has been conducted on day-to-day basis, wherein the accused, who was in jail and defended by a counsel from legal aid, was compelled by the trial court to produce defense witnesses of his own in one day. It was impossible for the accused himself to produce Dr. Anil Kumar Singh and Dr. Kamlesh Kaitolia, the authors of the reports, that is Exhibit P72, in one day, because the said experts are government servants and could not have attended the court at the request of an accused in jail. The bench directed the trial court and the District Legal Service Authority Indore to provide assistance of a senior counsel to the appellant to contest the trial on his behalf. The judgment of conviction and sentence passed by the trial court and affirmed by the High Court is set aside, and the matter is remitted back to the trial court for Denovo trial by affording proper opportunity to the appellant to defend himself. Thank you. Please subscribe my channel, like this video and share this video. And if you have any doubts, please comment.